Good morning to one and all. This is Dr. MRK Prasad, Dean Faculty of Goa University and Principal of Salgaonkar Law College, Panaji, Goa. Welcome to the class of Access to Justice. We have learned access to justice from earlier MOOCs modules, and we had a lot of discussion on what is access to justice, how do you ensure access to justice. As we learn that access to justice has many facets, and we also learned that the constitutional mandate is that providing access to justice to everyone. It's the obligation of the state to provide equal access to the justice system, and we have learned a great deal under Article 14 that equality is a fundamental right to everybody. So, as a part of access to justice, we have developed 3 modules on how the legal aid was developed over a period of time in securing access to justice, particularly to the poor. The first module would be looking at access to justice developments prior to 1970. The second module would be dealing with the developments between 1970 to 76, and the third module would be looking at post 1976 developments. So, today's class we would be focusing on the first one, how the access to justice has developed prior to 1970 with special reference to the legal aid. So, what is the core objectives of this module or today's class is that we want to learn the pre-constitutional developments leading to access to justice. Then we will look into the contributions of Bombay Legal Aid Society and West Bengal Legal Aid Committee reports. Further, we would be looking at the 14th Law Commission report, which is the first Law Commission talking about the legal aid. And we also look at the efforts of the central government, particularly from 1952 to 1957, how the legal aid became a state obligation. Then we look at the scheme for legal aid to the poor. It was in 1960. Thereafter, we will be looking at the report of the Commission of Scheduled Castes and Scheduled Tribes. Then we will see an effort by a member of the parliament introducing free legal aid bill in 1970 as a private member bill. Then we will also look into contributions of National Conference on legal aid. So, this is what we are going to learn. The objective of this module is to see how these efforts crystallize the legal aid in future. So, before starting, we should understand that society is a web of human interactions. The society is nothing but how do we interact with another human being. And if you look at the initial stage of the development of the society, these interactions are simple. And in that sense, the primary function of the law is to regulate these human interactions that takes place in the society. The human interactions, when they are simple, dealing with that, the law is also simple. Therefore, there are no much trouble in understanding the law or following the law when the law is so simple. But however, human interactions becomes complex. They become complex when the societies change over a period of time. When human interactions becomes complex, social relations becomes more complex, law automatically becomes complex to deal with interactions. So, once the law becomes complicated, it becomes difficult for many people to understand it, and that results for a need of providing legal aid, and particularly the poor people who would not be able to afford legal services to understand these complex intricacies. So, therefore, the legal aid has become over a period of time an integral part of promoting access to justice. And if you look at the Indian history, it is no stranger to this development. So, recognizing its importance, the government India realizes that it is its obligation to provide equal access to justice in a new independent India. And that is the reason why even the constitution, when it was adopted, access to justice is its prime objective. And the many judges, jurists, and even the research scholars contributed towards this concept, and they contributed to the growth of the free legal aid, what we are looking at today, by several reports, several committees, etc. So, if you see that the roots of the free legal aid in India could be largely attributed to the Bombay Committee report. The Bombay Committee report drew the attention of the government to another report that was submitted in England, Rushcliffe report, which was submitted in 1944. With this backdrop, this module would be looking at how the origin of the legal aid has taken place, how it was grown and developed over a period of time till 1970 in India. So, this slide, it shows the various developments that taken place prior to 1970, which over a period of time in this class we will deal one after one. Now, to start with the Bombay Legal Aid Society, as I already said that the Bombay Legal Aid Committee was the main reason for starting it. The Bombay Legal Aid Society was registered in 1924 to provide free legal aid to all those who cannot afford. But for providing free legal aid to the poor, the society enrolled a few advocates to the panel, and it used to get financial assistance from the donations, government grants, membership, subscriptions, etc. As I told already, Bombay Legal Aid Committee has largely relied upon Rushcliffe Committee's recommendation. If you see, the Rushcliffe Committee recommendations on legal aid was submitted to the British Parliament, and the British Parliament accepted its recommendations, and as a result it enacted a Legal Aid and Advice Act way back in 1949. So, therefore, the Bombay Legal Aid Society brought this report to the attention of the central government and requested the government to appoint a similar committee to make recommendations on the need for legal aid to the poor in India. So, the government of India in 1946 itself wrote to the provincial governments, which you could loosely define them as state governments now, to provide free legal aid to the poor people in both civil and criminal cases. But the provincial governments expressed their inability on the ground that it would be very difficult for them as there is no adequate finances, and as such that the existing provisions in civil cases is sufficient to provide legal aid, but in criminal cases it will not be able to provide as there is no financial capacity to the provincial governments to provide free legal aid. However, the government of Bombay appointed a committee in March 1949 under the chairmanship of Justice Bhagwati, and this committee has submitted its report in October 49. The committee has made three major recommendations. The first one, the legal aid was the government's responsibility and the state was under duty to provide a lawyer if a person, a citizen, unable to hire a lawyer due to any financial constraints. So, therefore, a poor is entitled for a free legal aid and it becomes the obligation of the state. And number two, all the lawyers should be under the duty to undertake legal aid work. That means, being a professional, at least certain amount of time you should spend for providing free legal assistance to the poor. And further, the third recommendation made by the committee is that every lawyer at least should provide free legal aid for 6 cases without any fees. And if they accept more or if they are assigned more cases, then the fee will be prescribed by the government, which is equivalent to the government pleader. That means the first 6 cases you should be freely providing, and if the more cases were assigned to them, then he should be paid equivalent to the government freedom. And at the same time, the West Bengal government also appointed a committee under the chairmanship of Sir Arthur Trevor Harris, who is the Chief Justice of the Calcutta High Court, to make suggestions for judicial reforms in the state. So the committee, in addition to suggesting the judicial reforms, also dwelt on providing legal aid. However, the same reason, that is the financial inadequacy, the state government unable to implement the recommendations of this committee. The third initiative came from the Law Commission of India. The 14th Law Commission submitted its report in 1958. It studied both Bombay Legal Aid Committee and West Bengal Legal Aid Committee recommendations and approved their recommendations, and said that the free legal aid to the poor persons and persons of limited means must be provided by the state, and it is a duty of the modern state, particularly because when it is a welfare state, it owes that duty to the citizens. And it insisted that the states must accept this obligation. And it also talks about the states must provide funds for the legal aid to the poor. And in addition to the state responsibility, again the Law Commission, expressing its solidarity with the earlier report, says that it is also a responsibility of the legal professionals to provide free legal aid. The legal profession, according to the committee, owes a moral as well as social obligation to the poor in providing free legal aid to the poor persons, at least to some extent. Then further, the commission report says that before they could implement these legal aid schemes, the state should implement such schemes identified by the earlier committees, make provisions for legal aid in a gradual stages. That means even if you are not in a position to implement the entire scheme at a time, gradually try to implement it. And the committee also requested the government to take measures to adopt legal aid as soon as possible. Further, it says that the bar associations also should take immediate measures to render the legal aid on a voluntary basis. And its another recommendation is to amend Civil Procedure Code. It specifically talks about Rule 1, Order 33 of the Civil Procedure Code, which talks about pauper suits. The Commission suggests that it is better to define who is pauper, and also finds objectionable to use the word pauper, and it should be replaced by the expression of poor person or an assisted person. In 1952, the central government made several efforts to see that the legal aid is reaching to the poor. So in 1952, it recommended the state governments to make provisions for legal aid in criminal cases in respect of offences which are punishable with not less than 5 years rigorous imprisonment, and also an appeal from these arising out of these cases. That means the central government is requesting the states to provide legal aid to the poor if it is a criminal case where the offence is punishable with 5 years or above with a rigorous imprisonment. However, the same story repeats. The states express their inability due to financial constraints, hence it was not heeded. Again in January 1956, the Government of India wrote to the states to increase the scope of legal assistance to the poor, and they said that they are seriously considering of inclusion of this provision in 5 years plan. And the central government urged the states to make a provision for legal aid in the state budgets. Again, the states responded saying that they don't have sufficient financial stability to provide a special budget or allocate a special budget to the legal aid, and therefore the appeal failed to evoke any good response from the states. However, some state did make some kind of a contribution. If you look at it, is just a token of amount was allotted to the legal aid. It is ranging from 1000 rupees to 2000 rupees in the annual budget. And even though the central government promised that they are considering to include legal aid in the 5 years plan, the legal aid was given very little importance in the 5 years plan. That means both the central government as well as the state government, whatever the reasons, whether it is financial reasons or other considerations, are not very serious about implementing the legal aid. In 1957, the Kerala government adopted Kerala legal aid to the scheduled caste and scheduled tribes and the poor rules. Under these rules, any person whose monthly income is below 100 rupees is entitled for the legal aid, and this legal aid includes the fees to the advocates, and the poor persons were entitled to the legal aid in all criminal cases before the high courts, sessions courts, as well as before the magistrates. Further, the rules also says that the scheduled caste and scheduled tribes were entitled for this kind of legal aid. In 1957, the Law Ministers' Conference suggested that each state government should formulate a special scheme for the legal aid to the poor. And the most important thing under this conference is that the mandatory appointment of the committee at different levels to entertain applications from the poor. And it also insists that each state should forward the Central Ministry of Law regarding the schemes they have formulated in providing free legal aid. Then comes this outline of a scheme for legal aid to the poor. So this is a scheme that was brought by the central government in 1960. This scheme is mainly aimed at providing legal aid to the poor. As the name suggests, it is called as outline of a scheme for legal aid to the poor 1960. It clearly specifies three things. Number one, the facilities to be made available under the legal aid. Second, mode of functioning of the legal aid. And third one, the source of financial assistance. So these are the three things that was clearly specified in this scheme. And the scheme clearly laid down the following things. Number one, what is the professional assistance you should be given? It talks about the remission of the court fees, processing fees, substance and traveling allowance for the witnesses, and it also talks about free certified copies of the judgments to be given to the litigants, and free preparation of appeal paper books, including printing, translation of documents. So that means for the first time this scheme gives a detailed list of what is entitled under the free legal aid. And it also proposed for the constitution of three different authorities. That is to say, the state legal aid committee, the first one at the state level. At the district level, the district legal aid committee is the second one. At the third level, that is the local level, the taluka or tahsil legal aid committees. So all these three committees are supposed to provide legal aid both in civil as well as criminal cases. And the most notable contribution from this scheme is that for the first time it provides three tests for eligibility to claim a legal aid. That means it's not that everybody would be free to get legal aid. They need to satisfy three things. Number one, the first one is the means test. As the name suggests, that the first qualification for the person to claim legal aid is that his inability to pay for the legal assistance, and that inability to pay for the legal assistance is due to poor financial resources. The second one is prima facie test, that is whether there is an existence of prima facie case in favor of the petitioner who wanted to file a case but unable to file a case because of want of financial stability. The third one is the reasonable test. The reasonable test says that for protecting the interest of the justice, is it reasonable to file this particular case? If the answer is yes, then yes, the person is entitled for legal aid. So, he has to clear means test, he has to show that there is a prima facie case in favor of him, and the third one is that it is reasonable to file such a case to get the justice for him. And for the first time, the scheme also talks about giving a statutory force for this legal aid scheme. That means, till now, the legal aid is going to be like any other scheme of welfare schemes, but for the first time it says that this may not be sufficient, better to give a statutory force. And it also said that every legal aid committee should have an office, and this office should be open during the entire office hours. And further it says the period for which an application for the legal aid remains pending before the legal aid committee shall be excluded from the computation of the period of limitation, as a very, very important recommendation, because as we know that every litigation has a limitation period. However, counting that litigation period, the period that this application pending before the legal aid committee would be excluded. So that gives a lot of leverage for the poor people when they are approaching for the legal aid committee for a free legal aid. And it also proposed for creation of legal aid fund in every state, because one of the problem that we are facing is that there is no financial support for these legal aid schemes, and the government is not in a position to provide financial support. So it proposes that legal aid fund in every state should consist money received from the state government, grants received from the central government, contribution made by partially admitted persons. It also involves the cost that is awarded by the court to the opponents, and fee also received from the legal advice, and also it says that even a private donations can become part of the legal aid fund. So it's a very good suggestion that each state should have a fund for it. And the suggestion of this committee, but unfortunately, though it talks about how the finances should be raised, but it has the same fate as the other reports and other recommendations, as it could not be implemented due to financial inadequacy. And even though the central government tried to provide some financial assistance to implement this scheme, unfortunately a financial emergency was declared during those days due to the Chinese aggression. Hence this is not materialized. So as a result, all these important recommendations of this scheme is remained on paper still today. Similarly, there is another report, this time it is coming from the Commission of Scheduled Caste and Scheduled Tribe. So a report was given by the government to the Government of India by the Scheduled Caste and Scheduled Tribe Commission, which suggested that the legal aid should be made available to the Scheduled Caste and Scheduled Tribes. The report highlights various aspects of making payments to the lawyers involved in the process of providing legal aid. It lays down that the fee that is to be paid to the lawyers associated with the legal aid should be on the scale of fee paid to the government cases. That means how much you are paying to the government cases to a lawyer, a similar amount should be paid to the advocates who are representing poor people. And the most notable development came by way of Free Legal Aid Bill in 1970. It's an initiation by Mr. Madhu Limai, who is a member of the parliament. He introduced this bill as a private member bill in January 30, 1970. I think this is the first attempt to provide legal aid with a statutory backing. The bill aimed at enacting a law for legal aid to the poor and needy persons involved in criminal cases. It was introduced in the Lok Sabha on March 13, 1970. The object or the reasons why this bill was introduced is to implement the fundamental right under Article 22 of the Constitution of India. Article 22 of the Constitution of India gives a fundamental right to every arrested person right to represent through a lawyer of his or her own choice. To implement or to protect that right, a statutory or a mandatory provision of providing free legal aid to these people is necessary. And also, because of the poverty, the large number of people are unable to avail the services of lawyers. This bill was also introduced for that. And it was also felt that every civilized country considers that it is their responsibility to provide free legal aid to assist those people who are indigent. And also it taken into the consideration that at present in India, very few cases where the legal aid was provided. Usually the legal aid was provided in some of the cases where capital punishment is the sentence. But in other offenses, usually the legal aid is not provided to the arrested and accused persons. So the bill may impose, if the bill is passed, it may impose some kind of financial liability or a burden on the state, but it would act as a deterrent against indiscriminate arrest and framing false charges against the people. And provision for this legal assistance would also ensure a fair trial and a better administration of justice, again which is a basic fundamental right of every person under Article 21 of the Constitution. The provisions of the Free Legal Aid Bill 1970 as follows. The central government and the state government respectively asked to publish in an official gazette about who is entitled for the legal aid. It proposes a stage-wise implementation. Unlike other schemes where it requires you to implement at a time, the bill considers the financial status of the states. Therefore, it says that you introduce this legal aid stage-wise. It says every 3 years, 1/3 of the administrative units or districts within the jurisdiction of the union territories or within the jurisdiction of the state must implement the scheme. That means if it is a state, 1/3 of the state should be implemented within 3 years. Then every 3 years you have to add 1/3. So as a result, what happened, within 9 years, the entire territory is covered with this bill. That means the act would apply or completely enforceable within 9 years throughout the territory of India. However, the bill is not passed. So the National Conference on Legal Aid, the another initiative towards providing legal aid, a National Conference on Legal Aid was held under the chairmanship of the eminent lawyer, the Supreme Court advocate late Dr. L.M. Singhvi. He identified, or I would rather say that he realized that the task of organizing legal aid to a country like India, is a vast country, number of people more and more poor people, it's a very challenging task. It was stated that the legal aid program was not uniform in India. Each state has their own different style. Therefore, there is a need for bringing uniformity. The scope of legal aid was very limited, and the scarcity of the funds were the major problem, as we have seen throughout what we are discussing, that the finance is the major reason for not providing the legal aid. Therefore, making legal aid as a reality, state would have to allocate a substantial funds for the free legal aid. That is what he insisted through this national conference. He further added that the Indian Bar Council, which is the second largest bar in the world, which should be utilized for providing free legal aid. And for the first time, he recognizes the value of the law students and says that they should be involved in providing legal aid. And he also says that involving the law students would make the law students socially responsible. They would become better lawyers and better citizens, because early exposure to the problems of the poor would be a great help to the students in understanding the importance of the legal aid. Then the conference also led to an amendment to the Advocates Act 1961. So in the year 1970, it was amended, and the Bar Council was called upon to take upon the responsibility of the legal aid without the aid of the state governments. That means without financial commitments either from the central government or state government, it becomes the responsibility of the Bar Council to provide legal aid. So, to conclude or to see what happened throughout from 1949 to 1970, what these developments achieved in providing legal aid, I would say number one, it sensitized everybody that the legal aid is necessary, and it is not only a state obligation, but it is also a professional obligation on the part of the lawyers. The second one, what I look at it is the realization of the importance of legal aid. So, it highlighted how important legal aid to the poor is necessary, and that legal aid should be a free legal aid to the poor. And at the same time, though we realize the importance, we also understand the challenges. It is a huge, gigantic task to provide legal aid for so many people. And also we found that the financial stability of the state is very, very important in providing legal aid. And another important thing is that all these efforts has resulted in a movement for a legal aid. It formed a base for the subsequent developments, which we would see in the next class, the developments between 1970 till 1976, that all the further reports, the further recommendations, these are the fertile grounds from where they got these recommendations. So, on a whole, we would leave today's class that we understand that the legal aid is very important for providing access to justice. However, if the class has any questions or any clarifications required, you are free to write to us, join in the forum. You could ask questions, you could make comments, we would respond to you. Thank you.